Hey, Paul here, and in this video, we're going to discuss how a married person can have their own valid handwritten will, leaving their estate to their spouse. Okay, so certain states, including Louisiana and 25 others, allow people to have handwritten wills. And in this sample demonstration, we're going to show you how a married person in Louisiana can have their own handwritten will where they leave ownership of their estate to their spouse and they provide for what happens to their estate if their spouse predeceases them. All right, so a few things before we get started. This obviously is not the perfect form for every couple out there. There are so many different couples with so many different unique circumstances. But in today, when many seniors are under stay-at-home orders, they don't want to get out. They can't get out. No one can come into their home, and so they're stuck and they can't get estate planning legal documents done. So this might be appropriate for some of those married couples who want to get things done quickly and want to have that handwritten will because it's easier to get that done to satisfy the relaxed formality requirements. Okay, so this is an example where in Louisiana, we have what's called forced heirship. So this would be an example where there were no forced heirs. Forced heirs are children of yours who at the time of your death are 23 years of age or younger, or they're any age, but they're incapacitated. So if you have no forced heirs, it is okay to leave your estate, leave the ownership of your estate to your spouse. You're not required to leave anything to your children. Also in this form, you got to be okay with the fact that when it does go to your children or to your heirs, it goes to them outright. It's not going to be managed in trust where someone else manages their inheritance for them and doles it out to them. Also, just note that only 26 states permit handwritten wills. Your state may be different. In fact, if you are in one of the 26 states that permits handwritten wills, every state's rules may be a little bit different. So you have to be aware of that. So this complies with all of the Louisiana requirements. And in Louisiana, the main requirements, and really the only requirements for a valid handwritten, or as we say it, olographic testament, is that the testament or the will be entirely written, dated, and signed in your own handwriting. So there's two forms of valid wills in Louisiana. This is the olographic will, like I said, entirely written, dated, and signed in your own handwriting. And then there's the other form called the notarial testament, which is the more traditional typed up, typically by a lawyer. It's notarized. There's two witnesses. There's what's called an attestation clause that makes the typed up will valid. But all of those notary witness requirements are not required for an olographic testament. All right, so let's take a look at this form. Has to be dated in your own handwriting. So at the top, a person would put the date here. This first sentence is going to be virtually in every will. And then the person writing the will writes their name. I declare this to be my last will and testament, revoking all prior wills and codicils. A codicil is an amendment to a will. So we just want to make sure all those prior things are revoked. And then here's the big sentence right here. I leave my estate to Jane Doe. So in this case, John Doe's writing the will. His wife, her name is Jane Doe. He wants to leave everything that he owns to her. He wants her to own it after he dies. I leave my estate to Jane Doe. Simple enough. Now, whenever you leave things to your spouse, you also want to provide for what will happen if your spouse predeceases you. Well, your spouse is probably in the same generation or so as you, so there's a pretty good chance that your spouse might die before you. So you want to cover that. And in this case here, it says, if Jane Doe predeceases me, I leave my estate to Peter Doe, Susan Doe, and Joseph Doe equally. So perhaps those three are the three children that John has. Maybe they're the three children that John and Jane have. But it doesn't have to be the children. It could be grandchildren. It could be other relatives. It could be unrelated people. But this is a scenario where if your spouse predeceases you, this is a scenario where you would leave things to certain people equally. And then the last paragraph here, the important executor paragraph, I name Jane Doe as executor. Again, most married people name their spouse as the executor, especially when they're leaving their estate to their spouse. I name Peter Doe as alternate executor. Peter is one of the heirs, so one of the heirs is typically a good person to name as the backup or alternate executor after the spouse. And then this important sentence, my executor may act as an independent executor, that allows your executor to act under the more streamlined independent executor provisions. Let me show you another sample. The only thing that's going to change is what happens if your spouse predeceases you or dies before you. So in this form, if Jane were to predecease John, then when John died, John's estate was to go to these three people equally. Let's assume that's John's children. And in this form, the only thing that's different is John wanted, if Jane died before him, John wanted his estate to go to these three people in these different percentages. So this would be appropriate to use when you had a number of heirs who were over 18 or older, but you didn't want to leave it to them equally. You wanted to leave it to percentages. Want to make sure, of course, the percentages add up to 100. So this is an example for that. Now, a few other points to consider. Even though you'll have a will and it'll be a valid will, there's still going to be a succession or what other states call a probate required when you die. If you die with a home or with something in your name, it's going to be frozen when you die, even if you have a will, and your survivors are going to have to go through the court and attorney involvement of a succession, or other states call it probate. If you want to arrange your legal affairs so that all of that court and attorney involvement is avoided when you die, you'll need to look at getting perhaps a revocable living trust, titling things in your trust, and then when it's done that way, the court and attorney involvement of a succession or a probate is avoided. And just another point, I mean, the handwritten or olographic will, from a formality and validity and legality standpoint, is every bit as valid as the more traditional typed up will by an attorney, notary, two witnesses, the appropriate language that makes it a valid notarial testament. This is not any more or less valid than the notarial testament, because here in Louisiana, we have two forms of testaments: olographic, which is this, notarial, which is the other. Neither one is more valid than the other. Now, what I'm showing you here, it certainly doesn't cover every set of circumstances. So this is a scenario where John left ownership of his estate to his wife, Jane. And some people don't like that. But what John did here was he left it all to Jane. Now, once Jane gets it, she has her estate. She had what was formerly John's estate. She's got it all. And maybe she did a will just like John's, where she left everything to John. But nonetheless, if John dies first and leaves everything to Jane, Jane can write a new will and leave the entire estate, both Jane's and what was formerly John's. She could leave that to other people. She could change the percentages. She could leave it to a new spouse if she remarries. So there's no protection in place here for John's children once John dies and ownership of everything goes to Jane. Now, for those married people who want protections for the children, maybe they should do their will a different way by leaving things in trust for their spouse. And then when their spouse dies, the trust assets revert back to their children or their heirs. In Louisiana, we have a special form of ownership called usufruct, also provides protections for the children of the first spouse to die. So those could be in future videos, perhaps. And this form here, it doesn't cover anything about who would raise the minor children. This is really for those, people who their children are adults. There's no forced heirship, no 23 or younger children, and okay if the children get it all in a lump sum or in full ownership. Also, in this form here, there's no provision for co-executors. Some people want to have that. And again, just a reminder that there's not going to be any kind of succession or probate avoided by having a will like this and leaving everything in your name. Now, I will tell you that lawyers in general discourage handwritten wills for two reasons. One is more of a self-serving reason. They want consumers, of course, to go to the lawyers and pay the lawyers attorney fees for getting wills prepared, and I get that. And then the other reason lawyers discourage handwritten wills, and it's a valid reason, is that without the proper instruction, without the proper wording, without the proper terminology and all the phraseology, I've seen a lot of handwritten wills over the years come into my office after somebody died, and sometimes handwritten wills can do more harm than good. However, with the proper instruction and the proper wording, it may very well accomplish exactly what you're trying to accomplish. So this is the first video of its kind that I've done where I've put a sample will or two up on the screen and talked through it to give people an opportunity if they want to. Those do-it-yourselfers. Not everybody's like that, and not everybody can be that. Many people's situations are complex enough where they need a lawyer to help them work through the complexities or potential complexities of their estate. But I'm anxious to hear and read your comments below about what you think about this, whether you feel like it's helpful, whether you think, if this really gets expanded with more forms and more states, whether you think that would be something you'd actually use or take advantage of or share with others. So feel free to share your comments in below. One other favor I'll have is make sure you smash the like button, and then also so that you'll be informed as I expand this, make sure you hit the subscribe button and the notification bell so that the YouTube algorithms will put more of my estate planning videos in front of you. Okay, we'll see you next time.